If you are here for something else, you're in the wrong room, and it's not too late to find your way to the correct location. Well, I'm sure all of you signed up for this session because I dare to say, but I think I can speak for the entire panel, that this is the most interesting and important session there will be.
It's not like the Odyssey.
Well, you're here, so it must be true. Despite the fact that this conference offers a lot of interesting sessions, this is going to be the best one and the most entertaining and educational one. So we'll find out in about 75 minutes after whether that has any truth to it. Let me turn back the clock a little bit and start talking about some history. Some of you may be old enough to remember. In 1975, American Express launched what turned out to be a very, very successful advertising campaign. Initially, they started to promote their traveler checks. You know, traveler checks? These days, they don't know what that is, but and then soon that turned into a slogan for their American Express credit card. Don't leave home without it. Okay, that I'm sure some of you remember. You know, back then, I didn't think of it this way, but now when I look back, that was credit card was one of the earliest, the first network commodity or business. Right back then, when nobody was talking about multi-sided market and network externalities, all that. That's what it was. Now, and fast forward in 2018. In its own contribution to the antitrust jurisprudence, American Express prominently features its name once again. In the U.S. Supreme Court's 2018 decision in Ohio versus American Express, the Supreme Court held that the American Express anti-steering rule was okay under the U.S. federal antitrust laws because of the multi-sided product market. So it's not as simple as you may think. You have to look at different sides, different aspects of the product market. So the antitrust and American Express, I'm not here to promote antitrust, but to give you a little bit of a story of back then, it was, no one talked about it in terms of the digital economy and network economy. Of course, back then it was all analog stage. But today, I think we can actually apply the same analysis, same story. Today, probably you'll be thinking, don't leave home without your smartphone, right? Your smartphone is everything. With that device, you access Google, Facebook, Amazon, in Korea, Naver, Kakao, your bank account, everything. In fact, you cannot get by a single day with that physical device with all those programs, software programs. And that, if you think about it, because they are so convenient, so good, makes our life so much easier and interesting, we have probably unwillingly let them grow into what they are. Some critics now accuse them of being a monopolist, in the negative sense of the word. The monopolists being want to push the boundary and flex their muscles and trying to get even bigger. Or are they actually a catalyst for innovation? You know, maybe the truth is somewhere in between, or maybe it's all of the above. Or you can even say, so what, they are monopolists. They offer so much convenience. I like them. And they could be benevolent dictators. Someone has to be a traffic cop. In any event, I want someone to do that, and I am happy with that. Do I pay a higher price? I don't know. I mean, a lot of things they offer is free. At least spatially, right? There are other ways. Or someone else pays for the subscription fee, like the app developers who cry that they have to choose and they have no choice but to use Google's and Apple's internet payment system if they want to play the game. Maybe not. That was what the anti-steering rule was about when you think about it in the Hawaii versus American Express case. And one last bit about the American Express. The American Express had a 16-year exclusive distribution deal, meaning with Costco. At Costco, you could only use American Express card, not Visa, not MasterCard. But that ended in 2016 when realizing there are other things than American Express. So Costco negotiated a much lower processing fee with Visa and went with Visa. Maybe that has to do with, I'm purely guessing here, maybe that had to do with American Express and decided to step up and enforce their anti-steering rule even more, and they got themselves into the, in front of the Supreme Court where they were totally vindicated. So that's the sort of the context. Today, we have an excellent panel, and as I said, this program is much better than anything else, although this conference offers many other things. So he did this, but and because we have an excellent panel. And let me introduce to you who we have. In alphabetical order, we have Ruth Chen. She's the Director and Associate General Counsel for Competition and Regulatory at Facebook Singapore. That's the Meta. She is basically head of all things antitrust for Meta for Asia Pacific. Next, we have Lynette Doty. She's an antitrust partner at the global law firm of Freshfield. She's the head of the China antitrust practice, and she's based in Beijing. In addition to her expertise in Chinese competition regimes law, she's also an expert in European and UK competition law, which she will be discussing today. Third, we have Christian Catona from the US. Next to me. He's Vice President of Global Competition and Regulatory Policy at Computer and Communication Industry Association. That's a trade association members including the Googles, the Microsoft, the Medias, and others. So when they're not fighting among themselves, I'm sure, there are times they don't. Christian will find the common ground and advocate certain policy positions for the entire trade association. That's the goal. Before joining this very powerful trade association, Christian was with the U.S. Federal Trade Commission for almost 15 years, spending time at both the International Affairs Division and also here's in Jerusalem, Technology Enforcement Task Force. And so he's rightfully, uniquely qualified to be on this panel and share with us a lot of these concerns. Next, we have economist on the panel, Elizabeth Wan. She's the Executive Vice President at the economic consulting firm, the Compass Lexicon, in its Boston and Beijing offices. She's one of the leading antitrust economists of today. She's also co-chair of this particular excellent program. Next, alphabetically, the last one is we have Hao Zhang. He's a managing partner of the energy drug law firm in China, and he's one of the most distinguished and highly recognized energy lawyers in all of China. And last but not least, I'm Cecil Chung, today's moderator and also program co-chair. To give you a little bit of background about me, I joined the Lutheran law firm 11 years ago to fend off foreign invasion, just as South Korea was opening its legal market. Before that, I spent some 24 years in Washington, D.C., 7 years with the U.S. Federal Trade Commission, blocking all those anti-competitive mergers. And then, so the light of the day is switched side, and I was with as an antitrust partner at two large U.S. law firms in Washington, D.C. And here I am today, trying to offer you both an interesting background and insight as to how all these things digital today. Now, before we actually get started in earnest, of course, we're a commercial break. The APA International Law section recently published an excellent ebook entitled Navigating EU Privacy and Data Protection Law, written by Greg Voss and Catherine Woodstock. You may purchase it as you make your way out, order it at the reception desk, or of course you can pull out your Samsung iPhone or sorry, not Samsung iPhone, Apple iPhone or Samsung Galaxy. there's a new brand. Third one should be available to alcohol company. And use that using one of those aforementioned programs to order it online. And with that, we'll get started. Oh, 25% discount.
Buy now.
I guess that was the single most important text that I forgot to mention. Thanks for reminding me. So we do all belong to ABA International Law section today, so we do need to do that. Now with that, we'll get started without further ado. So we'll learn from what's been going on in their respective jurisdiction. I'm sure these days you cannot help but read about some new developments. The US DOJ trial against Google regarding tech study recently. That's going to go on. And there are all these things happening. DMA in Europe, and many other things. Of course, here in Korea, there are a lot of other interesting things that are happening. But first, let's hear from Yvette about what's been going on recently in Europe and also maybe possibly in China as well. We'll have to do the whole country.
Thank you very much, Cecil. Thank you for the kind introduction. One of the things we were talking about earlier was our little disclaimer. Obviously, all the things that I say are personal. A number of my colleagues are involved in various bits of litigation in the US and working quite closely with some of the companies that may be mentioned today. So I just wanted to make that clear. I think when you take a look at the EU, certainly Margaret Vestager would say that the DMA, the Digital Markets Act, is the gold standard. Because that's the way they may perhaps like that to be perceived, the gold standard for regulating the big tech companies on an ex-ante basis. It was first proposed in December 2020, but it really took quite a while to really get it off the ground, and it finally entered into force in November last year, essentially meaning that companies that were designated as so-called gatekeepers had to comply or had to submit a notification to the European Commission if they met certain conditions. We can talk about the conditions later if that's of interest. So that's what actually happened. And since then, the European Commission has now designated 6 companies as gatekeepers, namely Google, Amazon, Apple, ByteDance, Meta, and Microsoft. Now, for some of us, some of these designations will not come with much surprise. Alongside the designations, it's not only the company being designated, but there are particular sectors, particular services and applications where the European Commission has deemed that they are gatekeepers. And they include, for example, social networking, where the likes of TikTok, Facebook, and LinkedIn have been reported, intermediation services, advertising, operating systems, web browsers, search, video sharing, and web messaging. So again, as I mentioned, I think we all use these products, we all use these services, and so to some extent it will come as no surprise when that is taken into account. Having said that, though, it wasn't sort of slam dunk for the European Commission, because parties were also given the opportunity to indicate and to provide arguments as to why particular services should not be regarded as not designated for gatekeepers purposes. So, for example, you had Google, Microsoft, and Samsung that made recommendations or presented arguments with respect to their respective Gmail, Outlook, and Samsung's internet browser and related platforms. And what the European Commission said was that, from their perspective, they agreed with the parties that these were not to be regarded as core platform services. When you talk about the conditions, essentially then, what the parties
had to show or were required to notify if they met these conditions, really they fall into three buckets, cumulative criteria. One being to demonstrate that there is a significant impact within the EU internal market in at least 3 member states, there are certain turnover requirements to be met, and also market cap requirements to be met. Secondly, to be a core platform necessary to basically demonstrate, to show that it's an important gateway for business users to reach end users. And the final criterion was that companies enjoyed entrenched and durable positions, or were likely to in the foreseeable future, if indeed these cumulative criteria were actually met. I think from my perspective, perhaps a few points to note are the following. The first point I've already made, it's probably no surprise that some of these companies are regarded as gatekeepers. The second point that I think is perhaps more important, and we'll can talk about it later on as we continue our discussions, is this will impose enormous administrative, costly costs on the parties. When you take account of the obligations, for example, interoperability obligations, transparency obligations, and many of the other conditions that are set forth, some companies will have to create and adapt their products and services to be able to meet those criteria. Having said all that, though, and I think this is the third point, I'm trying to be objective here, though I have reservations about the DMA as dealt with. Having said all of this, though, in a sense, this particular tool is not materially different from other tools, other approaches that the European Commission or the European Union has taken. So when you look at the heart of the DMA, what you do see is that, in a sense, you see evidence, if you will, of the ordoliberal theory, which was developed very much in Germany following the Second World War. Now, why do I say that? I think what the DMA seeks to do is that it recognizes that we do need to support, we do need to allow free market as it will rule the day. But the element where you do see the ordoliberal theory as well come into play is that there's also a recognition or an acknowledgement that there needs to be government intervention precisely to ensure that there is fair competition that remains in play. It's essentially based on this belief, this notion that if government is not actually in a sense to promote, to foster competition, then monopolies will have an opportunity to emerge. My own view is that it remains to be seen whether what I would call an experiment, it remains to be seen whether the DMA will actually be as successful as, say, it will be. Because when it was established, when it was created, at its heart, the stated intention were really two things: fairness and ensuring contestability of markets within the European Union, within the EU internal market. And I do think that the jury is out to see whether or not there will be additional innovation over and above that which big tech companies, these designated gatekeepers, whether there will be that going forward as a matter of practice, or indeed whether new competition, entirely new companies, for example, will emerge as a result of the DMA. Again, as I said, I think the jury is very much out, and we'll have to wait and see. Maybe one final note, and I'll pivot to Asia. Where we are in Asia for this conference. And I think, as my fellow panelists will also share, you'll see that there are different countries in this part of the world that are seeking to emulate, to some extent, or at least contemplating a DMA-like type form of regulation. If I take China, where I'm currently based, if you consider, for example, the antitrust guidelines for platform economy that was introduced by the Anti-Monopoly Commission, of course it's nowhere near as expansive in terms of length even at the very basic level. It's nowhere near as expansive as the DMA that the European Commission has introduced. However, what it does do is that it recognizes, and this is actually reflected in the anti-monopoly law as well, it does recognize that there is a quote-unquote special place, or there needs to be special attention paid to digital markets because of the rapid evolution of these markets and how they are affecting our economies around the world. And a concern, an inherent concern, that one needs to be careful that online digital spaces are not effectively monopolized, are not the province of a very small number of companies. So I'll pause there with my opening remarks, Cecil, if I may.
Thank you, Nanette, about the overview of DMA and also a little bit about the China. Now, staying with China for a moment, let's turn to ours on and
So thanks for your kind introduction. My name is Zhang Hao, I'm a managing partner from Angelo firm based in Beijing. I want to make some elaboration about the PRC and trust law, especially about its relation with the markets during the past years. Generally speaking, we think the digital markets, it could be a challenge and also opportunity to Chinese society as well as the Chinese law society. Now, a lot of the Chinese lawyer, academic, professor, and also Chinese authority begin to think about how to regulate their PRC digital markets in quite a different way from the traditional manufacturer and the traditional industry. They bring a lot of the challenge to Chinese specific law, including the IP law, the privacy and data protection law, Chinese national security law, as well as the consumer protection and antitrust law. I want to maybe elaborate the 3 points regarding the big change brought by the Chinese development of our digital economy. The first point is about the PRC legislative action. And you see, we have the Chinese antitrust law in 2008, and last year we experienced the big change towards our antitrust law. Because during those big change towards our antitrust law, we will think there's a lot of the things related to the digital market. You see, we just have set up a lot of the new systems such as the stop clock system. We set up the safe harbor, the system in principle. We also increase the penalty towards the violation in the area of the using of dominance, the cartel, as well as the concentration fighting. And it is first time in the PRC and trust law, our law stipulates that every online undertaking, if they want to take advantage of the platform rules to violate the PRC law, to do the damage to the Chinese consumer, to the competitors, is also kind of violation of the PRC law. So we think even this provision is quite general, and also this is the first time the Chinese law to stimulate the violation related to the digital markets. And also the Chinese authority, especially for the summer, has issued the full regulation regarding the different kind of violation. And in those kind of the full regulations, a lot of the specific provisions is related to the digital market. At the second point, I want to demonstrate some maybe very famous enforcement cases related to the digital market. We also handle a lot of the case in the defense to our crimes. You see, and during the past 3 years, there are a lot of the very high-profile cases, such as Summer imposed a penalty towards Alibaba, due to his violation of the abusing of dominance. This kind of model we say in China that means choose one from two. And the penalty amount is over 2.4 US in dollars. I think this is the biggest penalty imposed by PRC authority. We also see another very famous case. The Chinese authority give a penalty towards Meituan, another very famous Chinese platform for the restaurant and customers. And we also see the summer publish a lot of modifying the penalties towards a lot of the Chinese famous digital markets and taking such as Alibaba, Meituan, Tencent, etc., etc. And the last point is about the Chinese antitrust private litigation. You see, we don't like in the US, we don't have a trade damage. So in this regard, we don't have so many antitrust private litigations. We just focus on the Chinese authority to enforce the PRC antitrust law. But during the past series years, we also experienced more and more antitrust private litigations. In those kind of the private litigations, we want to see a very interesting phenomenon. A lot of the platform, they want to use the litigation or kind of the measures to push or give some pressure to their competitors. We see the Jingdong, we see the Alibaba, we see the Meituan, we see the TikTok, the Chinese counterparts, Douyin. They act as the plaintiffs in a lot of the Chinese antitrust private litigations. We also found a lot of the matchings on the Chinese platform, or even sometimes the final consumer, they act as the plaintiff to sue the Chinese giant, the platform and plaintiffs in Chinese courts. So generally speaking, we think this is a kind of the opportunity and also a challenge to Chinese antitrust lawyer. So it's our pleasure to have a discussion about those kind of the contents of the investigation, litigation, and the legislative activities with our friends in this section. Okay, thank you.
Thank you, Harold. Before I forget, if you have any questions, please hold them for a little bit longer. At the end of the session, we'll have a few minutes to entertain your questions. And I'm sure there'll be some questions, but some of them will be answered by the time we hear from the rest of the panel. With that, now let's move from China to Singapore and Southeast Asia. Ruth, this is your turn.
Thank you. Thank you, EBA, for the opportunity to share my thoughts. My thoughts are of my own and not of my company or my employer. And it's great. It's great to connect in the beautiful city of Seoul. So we've heard about European developments in DMA and then now China. And let me give you a bit of coverage around Singapore and other jurisdictions in Asia. So what's clear, I think, as a theme is that in Asia, there's no clear consensus of whether ex-ante regulations, such as the type of the DMA, is the right path forward. And if there is some sort of new legislative framework to develop in Asia, there's currently also no clear direction as to what type of law framework that would take up. And let me give you some examples to highlight that statement. So we go from one end of the spectrum, which is, for example, Singapore and Taiwan. I think Singapore is one of the jurisdictions that first started looking at digital issues, first focusing on e-commerce as early as 2015 with market studies. And then it had subsequently conducted several deep dives and studies into digital markets related topics. And these include data portability, data use, large data, and aggregation. And I think what's very interesting is the CCS, so the Competition and Consumer Commission of Singapore. they have done a number of these studies actually in collaboration with the other agencies in the jurisdiction. So the data privacy regulator as well as the IP agency. And so together we're looking at these issues quite holistically. Fast forward to, I think, more recently, the cumulative experience have led them to take the view that it is at this juncture at least more appropriate to update existing guidelines that help give businesses better clarity as to how this is issues, and to hold off on introducing any sort of large-scale wholesale revamp or actually reduction of the laws. Taiwan is another example of a wait-and-see jurisdiction where they have conducted, I think, a year-long study into digital issues with the culmination of a white paper that was released at the end of last year. And I think there they have taken a conscious decision too to actually hold off and observe the developments. As Nanette had mentioned, for example, on the DNA, that it is such a new instrument that it is important to actually see how it plays out. And the things that they have highlighted in the white paper that I think is quite important to point out is that it's important to look at local nuances and market characteristics of the jurisdiction, and then to take those into account and to actually tackle cases on a case-by-case basis. And then think about whether large-scale regulations make sense for the jurisdiction. Now, I've started at one end of the spectrum. We also have, for example, jurisdictions like Japan and Korea. I won't touch on Korea, because Cecil will be the expert here, but these jurisdictions, for example, have also conducted these studies and think about regulation from an issue-targeted specific approach. And so Japan, the JFTC, and also in parallel the DMCH, so I think it's Digital Markets Competition Headquarters, that's right. Have then also conducted parallel studies to actually then take a look at exactly what issue within the digital economy do we care most about. And then let's think about a targeted way to address these concerns. And so that started, I think, first with e-commerce, and then with digital advertising, and then the next topic that they're tackling right now is actually mobile ecosystems and app store issues. And so we are running the gamut, and I will quickly finish off and not take too much time, but the other jurisdictions that aren't actually thinking about wholesale regulations. And so Thailand is an example of that. I think as of last year, they did actually come up with an overarching law that is the Digital Platform Services Act, and it is precisely to impose obligations on digital platforms of a certain size, upon which then you have obligations such as reporting, transparency, and several others. And so other jurisdictions like India and Australia are also looking at whether a large revamp of the law is necessary, but I think it's too early to tell, and both these jurisdictions are really taking their time to understand the issues before they rush into legislation.
Thank you. And let's move on to the US and plus any others. Now, the Christian, as I mentioned earlier, has experience in both the US FTC and also this big trade association representing a big, large, strong company. So I'm sure he has very interesting thoughts for his own associations or the member companies. With that,
thank you so much, Susan. Thank you for the opportunity to join this panel discussion and grateful for the invitation as well. It really seems, as you've heard, starting from our introduction as well from Cecil, that I couldn't agree more. I think this discussion couldn't be more timely. And why is that? I have been practicing antitrust law and antitrust and competition law and doing antitrust policy internationally now for 18 years. And what I really see is, I think these issues have really never been this hotly discussed before. And even if you think about just the broader antitrust and competition policy questions, you see that much of the discussion really focuses on the technology space, however we would define it. And I think, it raises a number of really interesting questions that also is part of our, title for the panel as well. Are there new paradigms? Are there new issues? Have we been looking into the places where we have to, as whether it's competition enforcers, companies and practitioners and others in this space? So that's kind of like the very first observation that I think makes this discussion so extremely timely. The other really interesting perspective that I think is so important to keep in mind is, when it comes to competition policy and competition enforcement, you really see it's now getting tangled or mixed with a number of other policy areas that perhaps you have never seen the same way before. Often many of the issues we talk about today are not purely competition issues or competition concerns potentially in different jurisdictions, but they really touch on a number of interrelated policy areas, whether it's privacy and data protection, whether it's consumer protection, whether it's national security, intellectual property, and other issues. And it really raises the broader question how all of these questions then fit into often broader national digital agendas and national digital programs that individual jurisdictions seem to be working on. Whether it's at the EU level, what we've heard with the Digital Markets Act that MENA provided overview about whether it's BSA, the Digital Services Act, or a series of other regulatory tools that the European Union is introducing, or how some of these policy interactions are viewed in other jurisdictions, as I really should keep that in mind. But when it comes to what is happening globally, and then I will zoom in then on what is happening in the United States, what I really like to kind of put things into buckets is you really see three main developments. On the one hand, you really see a number of regulatory and legislative proposals in a number of jurisdictions, and of course I will not go into all the details of that. We've heard a number of examples from my fellow speakers, whether it's EU, whether it's the UK, the MCC, whether it's many of the developments in Asia Pacific, Australia, India, Thailand, others considering some of these regulatory proposals, and how they interact with broader other policy areas as well, which is crucial to keep in mind. Then focusing and zooming in more just on the competition policy space, we really see a number of policy initiatives that have really significant interaction and very significant impact in the technology space. And I will use a few examples from the United States and the US Federal Trade Commission and Department of Justice in recent years. And the third one is simply enforcement actions. We really see heightened scrutiny by a number of competition authorities of technology companies and their business practices worldwide. And again, I will refer to a couple of examples from the US. So when it comes to these three main buckets, on the one hand, regulatory legislative proposals, policy initiatives on the other hand, and the third item is ongoing enforcement actions. Zooming in on the US, you really see there's not that much happening on the first front, kind of like the regulatory and legislative proposal front. Over the last couple of years, there was one main bill in the US that has received a lot of attention and there was heavily discussed after DMCH. Abbreviation I will try this, the AICOA, some of you might have heard, the American Innovation and Online Choice Act, that was proposed in the US Congress in the previous term and really has received a lot of attention, often dubbed as the US self-referencing bill. To a certain degree, it had some provisions that to a certain degree were similar to some of the DMA-related provisions, but it was, like this US bill that really created a lot of discussion about the broader concept of competition and regulation and potentially the need to address any market issues in this space. Long story short, it really had a number of very significant concerns from a competition perspective, from a data privacy perspective, from a national security perspective, from a content moderation perspective, again, showing how the different policy areas are interrelated in this space. In the end, at the end of the last Congress, it simply did not have the political support in the US, and since then, it seems that it will not have much political backing for it. So we can put the legislative and regulatory proposals in the US to this time. Now, what is happening on the other two buckets, policy initiatives and enforcement? And you really see a lot of what is happening in the United States in that regard. Two federal antitrust agencies, Federal Trade Commission and the Department of Justice and Antitrust Division, have been particularly active in, on the one hand, enforcing matters against practices of technology companies, and on the other hand, coming up with significant policy initiatives that often are broader but would have significant impact in the technology space. To give you a few examples, in the policy area, merger enforcement and merger policy has been a key focus of both the DOJ and the FTC recently. Just a couple of examples, a couple of years ago, the FTC looked very closely under its so-called CSB, enforcement or, activities, looked into studying the last 10 years, 2010 to 19's acquisitions that took place in the technology space. And they often looked at also transactions that were either consummated or non-notified under the notification threshold to see if there are particular issues or concerns or there have been any transactions perhaps that the agency so-called didn't catch or that review. And interestingly, the findings were that there was no systemic concern or major issue in that space. But focusing on the merger enforcement and the merger policy front, very recently, some of you might have seen that the US agencies put out updated set of merger guidelines, which is the first update since 2010. And there have been a number of commentators raising a number of key questions and concerns about it. In fact, the public comment period just ended a few weeks ago, and the agencies received over 3,000 public comments, many of them highlighting a number of very serious concerns. On the one hand, kind of like a departure, the general departure from the previous lodestar of antitrust enforcement and consumer welfare in the United States has been highlighted in a number of these comments. Another key kind of like development and concern has been the new guidelines for the first time included a number of case examples and references to previous merger cases in the United States. However, most of them are from the 1960s and the 70s. So it raises the question then, what has happened over the last 40 years? Why the agencies haven't been using any of the more recent merger decisions, underscoring how merger enforcement is actually done by them in practice on a day-to-day basis. And also, to a certain degree, the agencies really went back to some structural presumptions to earlier examples, for 1992 guidelines, raising some of the key concentration thresholds from back there. Again, focusing less on efficiencies and what most recent economic studies and economic thinking have been providing. Just very briefly, in addition to the merger guidelines, the agencies also, the FTC, as part of the rulemaking process, put out its so-called rulemaking to change some of the rules regarding the pre-merger notification, the Hart-Scott-Rodino merger form, requiring under this change companies to provide what the agencies suggested would be about 45 times on average more information for them to provide. But in complex transactions, that could be even about 7-fold what is currently required by the agencies. Again, these are developments that are not only focused on the technology sector, but they raise a number of questions how they impact, for example, startup acquisitions, how they can actually chill innovation and potentially business activities and transactions in that space. And very last is kind of like the last point going into enforcement actions. We're not going into details on particular cases, but CISO also mentioned, for example, the US DOJ's ongoing trial in the Google search case that started in September, goes to mid-November. The FTC very recently also announced its monopolization lawsuit against Amazon, looking into practice of Amazon. And again, these cases raise a number of questions about the broader objectives of competition. Is it to protect competitors, which would be a new concept, away from what US antitrust has been focusing on, to protect competition and competitive process, in addition to issues raised by the relevant markets and basically the consumer harm competition in these cases. In addition to many merger enforcement actions that we see, whether it's Microsoft acquisition. So you really see at the US, the key developments have been less so on the legislative and regulatory side, but more at the agency level, focusing especially on policy initiatives and actual enforcement actions.
Derek, thank you. I suppose we can forget about getting any new law passed in the US. In the House of Representatives, they lost, they ousted the speaker. They don't have a speaker there. So, and they have more important things than antitrust to figure out first. So probably nothing new. I'm not sure what happened for a while. Now with that, we thought we were going to have an interesting conversation or discussion from an economist perspective in all this. Certainly, the economists should know more than us, just lawyers. So let's hear from Elizabeth and see what she has to say.
I'm not going to say Cecil because he has been said many times, but I will thank David, Schwartz, and Iwa, the ABA section of International Law, to bring the conference back to Seoul. I am an economist. I'm not from China. I'm not from the US. So I want to make sure that ABA, American Bar Association, is not just for American lawyers. So American Bar Association welcome people from outside US, like many of us here, and also American Bar Association welcome people not lawyers, so economists and academics and people not a lawyer should really consider joining us at the ABA. So back to our panel. So you have been hearing my fellow panelists talking about, from the legal perspective, the potential issues involving digital platforms. I want to share with you, from economic perspective, there's some recent thinking that has been involving digital platforms. So there are quite some unique characteristics that make digital platform unique. Some of them involving really long compared to traditional companies. Many of the digital platforms are larger, and their business model involving multiple sides, and quite of them are very different from the traditional way. And many products and services are free, and that have huge implications how we handle our analysis and competition issues. And another crucial difference is network effects. One of the potential thinking was that the larger, the better. So several key characteristics make digital platforms special, and there are concerns rising from those characteristics. I want to focus on one specific issue, specifically involving high entry barriers. The regulations, the competition concerns we have heard of have one common theme, which is digital platform. The fact that they have such unique characteristics make it hard for new entrants to come in, and also make the existing incumbent to be able to entrench their monopoly power. I want to focus on two factors that economic thinking in the last several years have making our understanding of the entry barrier related to digital platform advanced. So the first aspect is network effects. On the surface, people are thinking digital platform often have network effects, and that make it difficult for somebody new to enter. However, additional analysis and studies have shown that we understand network effect better. Network effect can be positive as well as negative. So when the network effect is positive, we see TikTok become viral and become a overnight success because people just spread the word so quickly. But on the flip side, if there's something bad goes on, then that reputation, that success can collapse very quickly as well. So network effect is a double-edged sword that can go both ways. So that's additional thinking we have learned. And the second part related to network effect is that, especially in mobile ecosystem, the apps, it's so cheap and so many, and people often have multiple apps for the same category. So for example, for me, I have, 5 or 6 apps that tracking my sleep because I sleep well. So I download like 5 of them and track deep sleep and light sleep and all that. So multi-homing, that is a new phenomenon involving mobile ecosystem. When there is multi-homing, that can largely mitigate network effect, including the positive network effect. So that makes trying new things easier, that make the entry easier as well. The second element in the entry analysis, which is whether there's high entry barrier in digital platform, is large data. We have heard many times some large network effect has large data, and therefore it's very hard for somebody to come in and to compete. But the recent study have shown that large data, we really need to take, it's much more complex than just the size and amount of data. So one idea is that people may have heard about economy of scale, and usually with large data, you're thinking about, larger, there's economy of scale. But there is also a diminishing return of scale in economics as well. So how large is large enough? At a certain point of time, the economy of scale gonna exhaust, and there's any additional data, the marginal contribution will be limited. Another new dimension, thinking about large data, is not all the data is the same. So they're fresh data. There's there's stale data, and there are studies have shown that the speed of decay of the value of data is really fast. So the news coverage, it takes seconds for a news no longer to be new. But for health data, actually the longer the better. You need to accumulate the patient's history. So we do need to be very careful to consider what is large data, what is network effect, and more study and more data has been accumulated in the past and make us aware that in digital platforms, it's just very complex, and we are catching up and accumulate our analysis to understand and better study the competition issues associated with digital platform.
Thank you. I knew that I would be disappointed. She did offer a lot of interesting insights that most people may not really think. Network effect, oh, it must be bad. No, it's not. Maybe not. It may not be a winner takes all. The multi-homing, that's a fancy way of saying, I can use multiple service providers for the same thing because they are slightly different ones. It's not like if I have one operating system, why would I need a second one, right? Maybe for some applications you actually can use multiple providers, so it's not like winner takes all. In any event, so it looks like there's a lot to be looked at, and it's not as simple as some would like to make it out to be. That's the big is that it's not that simple. With that, before moving on to the next round of questions, taking a slightly different level, let me give you a very short summary of what's been happening in Korea. Since we're in Korea, it probably makes sense to give you a short summary. Three things have been happening. Number one, the focus or the encouragement to adopt self-regulation. The digital economy is not one thing. It actually has multiple different segments. There could be hotel booking segment. It could be food delivery. And then, of course, there's Amazon, like the e-commerce retail stores where you order different things. So there are a number of different segments, and all of them have come up with draft self-regulation to thinking, hoping that maybe the KFTC or it could be someone else will stay away from them for better or for worse. But the government is taking this trust but verify approach. So it's good that these businesses are coming up with self-regulation proposals, but will not rely on it 100%. We'll be ready to act on it and have ex-ante regulation. In fact, South Korea was the first jurisdiction and still the only jurisdiction that very, very promptly passed a new law that banned mandatory in-app payment requirement. So basically, the App Store's operators, Apple and Google and the others, and I say you must use my system, my payment system included in this App Store. And by the way, you have to pay me 30%, or whatever the number may be. That's what the South Korea has done. And second, they are also looking at what a DMA-like system where they will designate certain companies and gatekeepers, probably with slightly different rules, a lower threshold, and impose extra restrictions on that. South Korea and the KFTC is not new to this regime. In fact, they're actually very experienced in it. In Korea, every year they designated large conglomerates and they revise the list. The current threshold is about 5 trillion Korean won. That hasn't changed over the past 16 years. So the list is growing. But the bottom line is they are already familiar with the system or regime where they designate certain companies and put extra restrictions on their ability to do certain things that whereas the smaller companies would be free to do. So if they adopt the DMA-like system and where they designate certain companies as gatekeepers or whatever you call it, they will be perfectly ready and able to do that. It's just doing it at a different space. Third, this is an important one. While this debate between what is better, between ex-ante regulation and self-regulation and all the other enforcement actions, the KFTC has been actually quite busy enforcing antitrust laws against various platforms. For example, Kakao Mobility for self-preferencing in tax-having services, and also against Google for basically the exclusivity idea. Google app where it demanded the new game studio getting on them and nowhere else. They also doing enforce the MFN like provision against Delivery Hero Korea, basically demanding most guaranteed price, which is MFN. In this case, you can call it the YMFN. They track down that one too. So ironically, maybe it actually shows that you don't need new ex-ante regulation. They were perfectly fine and capable of going after these perceived, actual, alleged, whatever it is, abuses by platforms in different segments of the digital economy using the current Korean laws on abuse of dominance and also unfair trade practice. Now, of course, you could actually point out that Korean law on the ban on unfair trade practices is like expanding Section 7 of the U.S. FTC Act that the lean part of the FTC love to have, that the Korea already has. So maybe in that sense, it's not really fair to compare that because Korean version of current law is already like expanded version of the U.S. FTC chair wants to have. So. But with that, I think the Korea will provide interesting examples and stories for us to talk about in the coming years. Now, in the interest of time, two things. Number one, the next round of questions. So we will give each panelist a shorter time, 3 minutes. You try to come up, complete your answer in 3 minutes. And second, just check. After this session, I think this room will be free until 3 p.m. So we could. But that means we could go over a few minutes, right? Usually we start not exactly at 1:15, but about 3 minutes of warming up time, so we probably could stay here until 5 minutes after. Assuming, and if there are a lot of interesting questions we just simply cannot turn down, maybe we'll stay longer, but we'll get to that once we get to that. And so we've been hearing from the panelists about what's been happening in the past few years or so. And there are already some discussions on that, but this time I want to ask each panelist about, so what does it all mean for companies? How do they navigate this global world where each jurisdiction may be tinkering with some different ideas, different rules, possibly at odds with each other? or do you use this common denominator, or do you use the just strictly rules and do it that way? It doesn't sound that efficient. And how about for the government agencies themselves? If they have to deal with, claim they work closely with the agencies in other countries, whether it's antitrust agencies or other sectoral regulators, how do they actually position themselves and adapt their styles to make sure that they don't unwittingly create an environment to make, especially their homegrown companies, suffer in the overseas market. So with all that, I think let's turn to Christian about it's an interesting insight on this issue. He's been thinking about it quite a bit. So let's ask Christian about his thoughts.
Thank you, Sis. Obviously, we have a lot to talk about, so I will focus on perhaps 3 key points. I've been thinking about these issues for a number of years, but in 3 minutes, 3 points on some of the practical considerations or ramifications of what is happening work that you just heard about. First, perhaps from a competition agency or regulatory perspective, I think it's really interesting to see the interrelationship of many of these proposals that we heard about worldwide, whether it's a DMA, DMU, in the UK, other jurisdictions, of course, in Asia Pacific, as they're considering different types of proposals. Also, putting in, for example, what Ruth mentioned, how Japan, since 2020, has been applying its Transparency Act, co-regulation and a voluntary approach to regulation. In addition to what Cecil just also mentioned, with competition tools in different jurisdictions, how enforcement in and of themselves, whether it's Korea and Japan's use of superior bargaining position types of provision, or other types of competition tools already in the toolkit can interrelate with some of these proposals. So I think it's very important for countries and jurisdictions, agencies, regulators to think about their own jurisdiction, their own economy and market. What are the issues? Are there any issues that should be addressed? And if so, what would be the best way to address that based on the toolkit they already have? And very importantly, what Ninette also mentioned regarding the DMA, often being described as the gold standard by the European Commission, is it really? Do we know what the success would mean? Like, it's not even fully operational based on the designation process. It will be fully operational next year, likely. And at that point, it will likely take years to see whether those principles of fairness and contestability will actually lead to results that, DG Comp and the broader European Commission had. So I would just caution in that regard and highlight the importance of studying these developments versus relying on these international experiments. The second quick point, focusing on international convergence or divergence in this space and fragmentation potentially from a regulatory perspective. This is something that for much of my 15-year career at the FTC, I focused on international cooperation and convergence, building those especially in, in the merger review area. What we really see now with these proposals in a number of countries is they're really going in every direction as we see, just the examples we talked about. On the one hand, we see that companies that are being regulated are obviously very often global or regional, need to say regulators and the competition authorities. They're national, they focus on their national rules and laws. And I think it can be very important when one thinks about the current narrative, which is often in the deglobalization and focusing on national interest base, which really goes back to the point that I made in my initial remarks, how national digital agendas and programs can come up with different solutions to potential issues in this regard. And we really see that many of these proposals simply don't exist in a political vacuum. Antitrust doesn't exist in a political vacuum. And in that regard, what we have seen over the last few decades, the growth and the widespread adoption of competition laws, to a certain degree, can be an issue here. If you think about 3 decades ago, there were only about 20 jurisdictions actively enforcing competition laws. In 3 decades to today, now it's 140 or so. It's an extremely quick growth in a short amount of time, which is an extremely positive development, seeing how antitrust authorities and competition policy became a broader part of the public policy in a number of countries. But now it also potentially leads to the point that issues that are not necessarily competition ones, whether it's online harm, whether it's other content moderation related issues, perhaps are being treated as something that should be addressed through competition tools or proposals. And I think this is a key issue we really have to keep in mind, because the fact that ex-ante proposals will address every perceived harm in markets is simply impossible. It will not happen. What we really have to focus on creating systems in which there's robust competition, and we really see ex post enforcement in a number of jurisdictions has been able to provide that. I would have a few other points, but I know in the interest of time, I will just stop there.
All right, thank you. That was very interesting. Let's move on to the next one.
Just in a few minutes, building on what Christian was talking about, I think I'd like to highlight some other areas as well. One is expect ongoing investigations from two perspectives. One, for example, as Christian just mentioned, companies now have charged until next year to be fully compliant. These are the companies that have been designated as gatekeepers. Now, time doesn't permit to go through each of the core platform services which have been designated as gatekeepers, but there's a great little summary on the European Commission. This is not promoting them, but it's a very good summary on the European Commission's website under the Digital Markets Policy, which summarizes the 6 companies and also the areas which have been designated. I just gave one example regarding social networking. So investigations are ongoing. Secondly, in terms of investigations, it's important to underline that yes, there is this ex-ante regulation, but the competition rules still remain in place. And within the EU, there are national member states who also have their competition rules, and some of them also have certain types of regulation as well, which also remain in place in parallel. And under the DMA mechanism, under the Act, member states, although they cannot initiate, as it were, and cannot establish that certain companies are gatekeepers, they can nonetheless initiate investigations. And in a sense, refer the matter up to the European Commission for them to designate a company, particular core platform service, as a gatekeeper. So ongoing investigations. I think the second and important, or the third important point to mention is that under the DMA there is one of the auxiliary obligations, again time didn't permit to go into all the obligations, but one of the auxiliary obligations is that once you've been designated, or a core platform service has been designated, you also have a reporting obligation vis-a-vis all your mergers and acquisitions, effectively irrespective of the level of investment. What that basically means is that every conceivable transaction presumably needs to come to the European Commission, and they may investigate that as part of their routine investigation processes, which then adds additional obligations, administrative burden on companies as well. A fourth point is the fact that there is private litigation, which is permissible under the DMA. Now, in practice, the obligations which have been imposed, not all of them will be easy enough to police, to monitor, and actually to implement. That's at least my suggestion, my submission. Some of the obligations include, obligations to enable interoperability, obligations to enable portability of data by end users, obligations to, or prohibitions against self-preferencing, or transparency requirements. Now, who's going to police that? And how is that going to be enforced in practice? Bearing in mind that private action is actually going to be available and damages can be sought, and of course quite separately, the European Commission can also impose fines if there is continued non-compliance. So again, it does mean that the compliance burden is increasingly heightened for companies. And then the final point, and I'll end with that very briefly, is also dispute resolution. Given the obligations regarding, say, interoperability, obligations around data portability, how do we guarantee privacy in this respect? And if there is a data breach, who is responsible for that? And in what circumstances should the parties be responsible? Should the third party that has been given access be responsible, for example, if there is a data breach, or if, in the context of interoperability, there is vulnerability that's created vis-a-vis the systems. I think for me, the overarching theme is really compliance, compliance, compliance. Indeed, under the DMA, the European Commission requires a compliance officer to be appointed. And I do think that compliance is going to be a big theme going forward, right across the different jurisdictions. And it will be challenging, in part, as Christian also mentioned, because you've got this disparate rules around the world, different speeds of development, and different areas that are emerging. And the real question, which I think Cecil rightly poses, so is there a common denominator? Now, which threshold do you actually use for the purposes of guaranteeing compliance? And I do think, whilst there is convergence in some areas, there are also some important differences, and it's going to be incumbent on companies to remain on top of what's going on, whether it's in Europe, the US, in China, but compliance will, I think, going to be the modus operandi going forward, much more so than it has been for digital market players.
Thank you. Now, ask Ruth for
Okay, I have a number of points, but conscious of time, so I want to just make one point. I want to make it really practical at picking up on the next point around compliance and give you a real scenario. As an in-house lawyer, when I have to advise the business on product rollout in several jurisdictions in the region, if I were to have to look at all of the various thresholds that are being proposed or already in effect, this is the type of analysis I would have to go through. And this is a global analysis to give you some idea of the novel concepts and challenges we have to deal with. I've got to assess, are we Gatekeeper? Are we a core platform service? And then I've also got to perhaps strategic market status from the UK. Then I've got to think about paramount significance for competition across the markets from Germany. Then there's the unavoidable trading partner term that could potentially come up or already in existence in several jurisdictions in Asia. And then if India introduces something, it could be along the lines of a systematically important digital intermediary. And if the product team is asking us, please assess global rollout within 48 hours, I will die at my desk. So compliance is a huge part of the legal function within an in-house, and thresholds like these can make it that much harder. Okay.
All right. Then how maybe you're going to do this question 2 minutes or less.
Yeah. Okay. This is a very interesting topic. I will maybe make some elaboration about the cases in my practice. I have mentioned before now Chinese authority and our legislative organization address a lot of the issues regarding the digital markets in our legal and our regulation. Sometimes I have some discussion with my clients. A lot of my clients belong to the Chinese e-commerce tycoon. Obviously, they are younger than me. They are the young millennials and millennials. So they always have some question regarding those new legislative activities. In one hand, they think those new rules regarding the digital markets can give more accuracy about their compliance, their deadline, and also there's some prediction about the risk in PRC society. But on the other hand, they think our legal law impose a lot of the obligation towards them. So a lot of them have some maybe questions. They think during the past 2 decades, maybe a lot of persons think that China made a very huge development regarding of the e-commerce. The main reason for that is the new regulation, because at that time our government organization or the legislative organization did not impose a lot of very concrete and detailed the guideline and regulation towards them. So they have enough space and freedom to make their investments. And a lot of person comments think the Chinese businessmen are very smart. They can make a wonderful combination between the internet and the Chinese business model. This is the reason why Chinese can found a lot of the pioneer in the e-commerce. Then it's time natural for our legislative organization to issue so many concrete guidelines and regulation is a kind of a wise decision or not a wise decision. So those things also just make me a little confused. Whilst acting as a practitioner, I welcome those new laws and the new regulations. It can bring in new business. But on the other hand, I also found, especially in the sector of the e-commerce, I want to maybe have more taxation with our counterparts in other jurisdiction to fund maybe are efficient and reasonable and fair way to regulate the new commerce. And the second point I want to say about the purpose of our antitrust law. You see, in China, we have a furious debate about what's the meaning, what's the contents, should be our purpose of our antitrust law. The person maybe think about a lot of persons the multi-purpose will be good, appropriate, such as we should have the purpose to improve our competition, to keep the protecting for our fair competition in Chinese society, and also want to protect the consumer rights for Chinese consumers. Something think it also will maybe have another kind of function to encourage the Chinese private undertakings to take into the fair competition with some SOEs. But there are some people who think that they think the sole purpose for the antitrust law should be improve the fair competition. That's all. That's enough. So there are also a lot of debates regarding this issue. I think if we could not fully understand the purpose of our competition law, then it will also bring a lot of confusion towards our enforcement and legislative activities and our private agents. So I'm very happy to maybe just give you some questions. I have no answer for that. I welcome my colleagues in the different jurisdictions have maybe fair and very maybe useful discussion about this issue. Thank you.
Okay, thank you. Elizabeth, your chance for your extra comments.
So I just want to make one comment. Competition analysis related to digital platform need to be very fact-specific and fact-intensive inquiry. We cannot assume somebody just have dominance or have the same impact on competition. Every product, every geography have their own characteristics. Just using Amazon as an example, we cannot assume Amazon face the same competitive constraint in US versus in Korea. We cannot assume Amazon face the same competitive constraint in e-commerce versus cloud computing. And we need to understand the specificity and how does the company react, how does the competitor react, how does consumer react, and the regulation need to be more aware and allow the market, the competition mechanism to work out its own way. So facts and need to be very specific. That's all I'm trying to say. Thank you.
Thank you. And I'm actually afraid to ask you if you have any questions, because number one, either you have too many questions, hard questions for us to answer, or you may have no questions because we're so clear on everything we talked about. But still, I suppose we do need to ask you if any of you have any questions, and we'll take just two easy questions for us to answer. So, If you have any questions, please raise your hand. Don't be shy.
People like their coffee.
Yeah, but basically we know as little about all these things as you do, so you ask me questions will not reveal your ignorance or lack of knowledge. In fact, we are all in the same boat, it's all trying to figure out what's going on and where it should be going, exactly you said. So, any questions? Oh, two questions. So you two are to Fiona, so we'll go with you first.
Yes,
Please.
In the 1960s, Aaron Drinker's foundation was that if the results is that the price is lower, then there's no harm to the consumers. And so that's pretty much the intellectual foundation for the antitrust. And apparently Chairman Kong does not agree that the criteria should be the lower price. So what is the Chairman Kong's new intellectual framework for antitrust?
Do you have anyone particular in mind on this panel to answer your questions?
Just there's only one, obviously.
Okay. Everybody's looking at you. I'm sure we are all equally capable of answering the question, but we'll give it to you.
I will try to do it in 1 minute or so. Having worked with 8 chairs and over 15 years, at the FTC, obviously, there have been some interesting experiences over the time. If you ask in one sentence, kind of like, what is the new framework or so, I think you see it's a work in progress, I'd say. In many of even the policy initiatives that I mentioned, whether it's in a merger space, merger guidelines reflect particular developments, the Hart-Scott-Rodino regarding the pre-merger notification form revision in that regard. Again, there is to a certain extent what commentators often highlighted as an antipathy towards mergers and merger activity in the United States. On the one hand, that might raise some basic questions, but then you also see a rethinking of goals and objectives of antitrust themselves, whether they should incorporate what previously were considered non-competition factors in antitrust analysis. It can be labor-related concerns, it can be sustainability. There has been a lot of discussion about some of those developments. But I think it also touches upon what many of us have covered regarding core principles of regulation, which in and of themselves might be laudable goals, whether it's fairness, whether it's sustainability, in the European Union's DNA. If you look at just regulation examples in the United States, a few decades ago, just in the transportation sector in the 1950s and 60s, using these two core principles, non-discrimination and fairness, the U.S. transportation sector brought a number of new regulations to supposedly help consumers in light of these principles. There were 2 agencies set up for this, the Interstate Commerce Commission and the Civil Enterprise Board. In a couple of decades, immediately, economists saw that the regulations that were brought to reflect non-discrimination and fairness actually harmed consumers, distorted competition, and didn't help the marketplace. What happened? A couple of decades later, those 2 agencies, for example, were disbanded. So I think it really shows examples that the fact that there might be principles that might even sound good, whether it's fairness, they're extremely difficult to apply in practice. And most importantly, talking about the regulatory perspective many of us have touched on. These things are extremely complex products, business models, and practices. And they change constantly over time. It's a very dynamic space. So even if theoretically there would be a perfect regulation as of today, tomorrow it's not. The products will change, the market characteristics will change, the market dynamics. What Elizabeth mentioned, those particular companies in different jurisdictions face very different market dynamics and market characteristics. There might be regional players, there might be global players, there might be national players. And I think that makes, the broader competition regulatory discussion even more important. How countries want to actually attract investment. because there's a global competition to attract investment as well. The regulatory framework countries provide will often decide whether companies will want to act there, operate there, whether there are excessive expenses and regulatory burden and compliance costs that Ninette mentioned. So in the US, I think one really sees, there are a number of questions that are being raised, and then how that could be characterized. I think the best way is a work in progress. What you really see is a certain movement, obviously from the last several decades, with some of the core principles that were more settled. Where it leads, I think none of us will know, but in case anyone has any further thoughts, I would love to hear them as well.
Yeah, there's some regional thoughts.
Just to add a lighter note to this, very recently I was listening to Richard Wish in a context of an interview or a discussion regarding digital markets, and many of you will know that Richard Wish is one of the leading academics in competition law for the past several decades, actually. And he made a very interesting observation. He basically says that for him, the goals and objectives is really around protecting consumer welfare, so long as you do not define what you mean by consumer welfare. Because it means different things to different people. And I think that's actually sage advice, because as societies evolve, and that's really the point I think that Christian was thinking of, as societies evolve, the concepts, the challenges, the issues which remain top of mind will differ over time. If I take China as an example, in the last, perhaps 2 years ago, I suppose now, there was heavy enforcement against some of the China's internet darlings. Investigations that took record 4 months or so, with record fines imposed. Maybe, some of us can learn from that. Fast investigations can help. But I think the more important point is that it had such an impact on the financial position, on the market position, in terms of market cap of these companies, listed companies, that what the Chinese government did was to take a step back. It does not mean that they are no longer being, on the radar, but the approach that the Chinese government has taken is different. It's more monitoring. It's more sort of calling people in and having discussions with them and encouraging them to modify their practices. Now that's a model that China has chosen. And I think what we're seeing in other jurisdictions is there's emphasis on other areas of concern or of interest, like labour issues and or sustainability. I think just not too long ago, the ACCC, for example, not to do with digital markets, but very recently the ACCC approved a deal, ostensibly a deal that would raise significant competition issues. They approved it because of sustainability considerations, because it was furthering the government's stated interest in promoting sustainability. So it's not so much the agencies that decide we're going to do this. It is a government that sets the tone. And I think what agencies are trying to do is to basically enforce that. You can argue they're going a bit too far in many, many instances, but I do think that that's a worthwhile consideration in practice.
A quick follow-up to Mr. Katana. Do you think that in light of the failed antitrust enforcement against AT&T, do you think that the U.S. antitrust law is more likely to fight against horizontal merger rather than a vertical merger?
I think when it comes to merger enforcement, we see a number of recent merger challenges in which the agencies actually, especially the FTC, haven't been successful. How and again, what it will lead to, I think it's interesting to see my initial introductory remarks. I mentioned on the one hand the enforcement actions, on the other the policy initiatives, which on the one hand, both on the merger notification front, seems to be making significantly more difficult for companies to submit, like pre-merger notification filings. On the other hand, on the merger analysis side, based on what the merger guidelines have been reflecting, which for the first time in 1968, I think the first one was like that, but this will apply, both horizontal and vertical mergers as well, they raise, I think, more questions than provide answers. So how it will lead to a slightly, very significantly different merger ecosystem in the United States, I think a quick and a very important concern. If you ask me, I see very serious concerns regarding how it can harm startup acquisitions, how it can have a significant impact on merger transactions. Many companies that perhaps wouldn't necessarily have, like the compliance capabilities, perhaps simply forego transaction, which again, regarding the broader concept of how efficiencies can help consumers and the broader economy, will likely get lost over time. So I have serious concerns in that regard where the merger enforcement and policy in the US is moving. But again, the shapes I think haven't really been, the contours haven't really been that clear in this regard. How economics, for example, will play a role in merger enforcement, which now has been changed to an appendix of the merger guidelines. Previously, it used to be a key concern and a focus of how you look at merger transactions and evaluate them from an economic perspective. Where it will lead, we'll see. You see many defeats recently in courts by the agencies, enforcement actions that they brought in the merger space. And you certainly see a kind of movement towards focusing more on protecting competitors versus focusing on protecting competition in the competitive process, which has been the lodestar and really the key focus of US antitrust enforcement. And needless to say, the very last point is how it will interact with international proposals and what is happening in other jurisdictions. As in a number of jurisdictions, I speak international in a lot of jurisdictions. I mentioned the AICMA example in the United States. I get the question in a number of jurisdictions. So that became a law in the United States. It did not. It was a proposal among many hundreds and thousands of other bills that the US Congress looks at every single year. But perhaps based on the fact that there has been so much discussion about it, people expect that to have been adopted as well, similar to the DNA, and that's not the case. So it's interesting to see how all the dynamics comes into place as people think, or now to certainly rethink the rules and course of objective competition policy.
Okay, thank you. Now, there was one question. If you promise to ask one simple question and with no follow-up questions, we'll entertain your question. Please go ahead.
He took mine.
All right.
Honestly, it was a requiem for the consumer welfare standard. So all these answers were perfect.
All right. Okay, in that case, I think that we have no further questions, or even if we do, I think we are really running out of time. We need to vacate this room during the minute for the next session. We hope you enjoyed this session as much as we did. And obviously, I think you can tell we really enjoyed this lively conversation. We learned as much explaining to you, and then you probably did from listening to us. And finally, if it was not as educational, it wasn't educational enough for to meet your high standard, and this you found it to be a slightly more entertaining than many other sessions you'll find in this conference. Thank you, and have a good day.